Yes, good afternoon, distinguished scholars and ladies and gentlemen. My name is Chizu Arashima. I'm an associate professor of international law from Kobe Gakuin University. Well, first I'd like to extend my gratitude to Professor Panda and Professor Minohara for their great friendship to have made their dream come true to have this wonderful symposium. And also I'd like to thank IDSA and Japan Foundation to co-organize this symposium. Thank you very much. And well, my presentation's title is, as you can see there, India-Japan Maritime Cooperation in Safeguarding the Freedom of Navigation and Innocent Passage, Implications from the Awards of the South China Sea Arbitration. Because I am an international lawyer, I'd like to focus on the interpretations of UNCLOS. And yes, and then this is structure of my presentation. First, introduction, and then I'd like to go on to the provisions of UNCLOS concerning the freedom of navigation and innocent passage, and then state practice, and then I'd like to go on to implication from the awards of the South China Sea Arbitration, and then conclusion. First, introduction. Well, as already stated by Japanese Ambassador Hiramatsu and some other speakers, Japan-India joint statement on 14 September this year underlined that India and Japan could play a central role in safeguarding the rules-based order by aligning Japan's free and open Indo-Pacific strategy with India's Act East policy. And the two prime ministers reaffirmed the importance of freedom of navigation and unimpeded lawful commerce in accordance with international law, notably the 1982 United Nations Convention on the Law of the Sea, which is UNCLOS. And in my presentation, I would like to focus on how India and Japan can foster future strategic cooperation to safeguard the freedom of navigation and innocent passage in the Indo-Pacific region in accordance with UNCLOS in the context of the freedom of movement of ships. That's why I include also the innocent passage by drawing implications from the awards of the arbitral tribunal on the South China Sea. Firstly, I would like to look at the provisions of UNCLOS as well as the difference in interpretations among states through state practice. Then I would like to review the awards on the South China Sea and see how the tribunal determined the entitlements of maritime features and therefore limited the activities of China in the South China Sea. And lastly, to conclude, I would like to point out first that the interpretation of UNCLOS delivered in the awards is the authoritative one for all the states parties to UNCLOS. Therefore, India and Japan, which both are parties to UNCLOS, can cooperate to safeguard the freedom of navigation and innocent passage by insisting that strict compliance of UNCLOS is necessary for all the state parties to UNCLOS. Then I'd like to go on to the provisions of UNCLOS and state practice. First, I'd like to look at the freedom of navigation. Well, the freedom of navigation is safeguarded in the high seas and the exclusive economic zones, which I call it EEZ. And the EEZ was introduced only after the entry into force of UNCLOS. Article 58, paragraph 1 of UNCLOS provides that in the EEZ, all states enjoy the freedom of navigation as in the high seas. And military activities in the EEZ are generally supported by state practice. However, the freedom of navigation is threatened by many coastal states. Those coastal states include Malaysia and Thailand, which do not allow military exercises without their consents. And India stated in its declaration to UNCLOS, paragraph B, that the provisions of UNCLOS do not authorize other states to carry out in the exclusive economic zone and on the continental shelf military exercises or maneuvers, in particular those involving the use of weapons or explosives without the consent of the coastal state. And China opposed any military operations in its EEZ without permission, according to the Chinese Foreign Ministry spokesman Hong Lei in November 26 this year. And none of these are authorized by UNCLOS because Article 58, paragraph 1 does not distinguish warships and commercial ships, where other provisions of UNCLOS clearly state warships where the distinction is necessary. And concerning innocent passage, in the context of the freedom of movement of ships, innocent passage in the territorial sea is provided in UNCLOS. For territorial seas, foreign ships are permitted more limited navigation than for the EEZ. According to Article 17 of UNCLOS, ships of all states again enjoy the rights of innocent passage through the territorial sea. And Article 19, paragraph 1 provides that passage is innocent so long as it is not prejudicial to the peace, good order, or security of the coastal state. The list in paragraph 2 is considered to be a comprehensive one of activities that would not be regarded innocent. And the list, I'd like to emphasize that the list does not include the entry itself of the foreign warships to the territorial seas. And regarding the state practice, some coastal states like Burma, China, and Malaysia require prior permission for warships to enter their territorial seas. And coastal states which require prior notification to transit the territorial sea are Korea, Vietnam, and Taiwan. But Article 19 refers to ships of all states, and again, it does not specify warships. Therefore, Article 19 should be interpreted to include warships, because in other contexts of UNCLOS, warships are specified when naval vessels have special treatment. So I'd like to go on to the implications from the awards of the South China Sea arbitration. One procedural history. Pursuant to Articles 286 and 287 of UNCLOS, the Philippines initiated an arbitration against China on 22nd January 2013. First, I'd like to look at the award on jurisdiction and admissibility of 29 October 2015. First, Chinese absence. China consistently rejected the jurisdiction and participation in the arbitration, but according to Article 9 of Annex 7 to UNCLOS, absence of a party or failure of a party to defend its case shall not constitute a bar to proceedings. Therefore, non-participating China is still a party to the arbitration and shall be bound by the awards issued by the tribunal. Then the tribunal went on to consider whether the China's declaration in 2006 was applied to this case. On 25th August 2006, China made a declaration to UNCLOS that concerning the application of the compulsory binding procedures for the settlement of disputes, it excludes, among others, disputes concerning the interpretation or application of sea boundary delimitations or those involving historic titles. And concerning the former, the tribunal made a distinction between a dispute concerning the existence of an entitlement to maritime zones and that concerning the delimitation of those zones in an area where the entitlements of the parties overlap. And concerning the latter, it was examined in the award on the merits afterwards. And existence of a dispute between parties, I like to just go quick up concerning number 3 and number 4. The tribunal at last admitted that there is a dispute between parties, and then the tribunal admitted that it has jurisdiction over this case. And I'd like to go on to award of merits on 12th July 2016. Concerning the historic rights and the 9-dash line, And well, the tribunal first considered whether any historic rights claimed by China are covered by the exclusion from jurisdiction for disputes concerning historic titles. And the 9-dash line, you can see, maybe you can see from this map. This is a map of China, which was delivered to the United Nations Secretary General in 2009. And in its notes, China mentioned that it has indispensable sovereignty over the islands in the South China Sea and the adjacent waters. Maybe you can see 9-dash lines over there. And China insisted that about 80% of the South China Sea belong to Chinese territory. And let's see. Yes, and the tribunal's view is that the drafters of UNCLOS understood that the historic titles as claims of sovereignty over maritime areas derived from historical circumstances. But no provision of UNCLOS provides other historic rights China claimed, which fall short of sovereignty or those rights to the living and non-living resources of the EEZ. Therefore, the tribunal clearly denied the China's historic rights over the area circled by 9-dash line, which includes the area where China cannot claim its EEZ under UNCLOS even if the Spratly Islands are Chinese territories. And then the tribunal went on to consider the status of features in the South China Sea. According to Article 121 of UNCLOS, islands are entitled to generate an EEZ and continental shelf, while rocks which cannot sustain human habitation or economic life of its own are not. And well, I will skip. And the tribunal finally concluded that all the high tide features in the South China Sea are rocks under Article 121, paragraph 3 of UNCLOS, which means that all the high tide features cannot claim entitlements to EEZ or continental shelf, but only can claim territorial seas. So it means that sea adjacent to the territorial seas of those rocks are either high seas or EEZs of another states, where all ships can enjoy the rights of free navigation without prior notifications or permissions. In this sense, Chinese activities and jurisdiction are to be further limited. So you can see in this map that you can see the Spratly Islands and the area which is white or which is blank, the possible territories or possible territorial seas of China, if those islands belong to China. And I'd like to go on to the prospects of the future resolution of the dispute. Although China has been insisting not to be bound by the awards, there was an actual progress towards solving the conflicts between the parties. After the summit meeting of the Philippines and China, China withdrew its vessels from the Scarborough Shoal, where China had effectively controlled. It may well be said that the awards and pressure from the international society led China to act in that way. And also it should be noted that China is not against safeguarding the freedom of navigation. Chinese Premier Li said at the 12th East Asia Summit on 14th November this year that China would safeguard the freedom of navigation in the South China Sea firmly. However, as was seen in the state practice, China interprets the freedom of navigation and innocent passage differently from the majority of the parties to UNCLOS. And I'd like to go on to the conclusion. And even if the awards of the tribunal bind only the disputing states, which is the Philippines and the Republic of China, the interpretation of the tribunal, which is provided with the power to interpret UNCLOS, is the authoritative one which every state party to UNCLOS should take into account. And some states attempt to restrict the freedom of navigation, as was seen in the state practice. It is crucial for India and Japan to resist those efforts hindering the free movement of ships, since the failure to do so can be regarded as acceptance of those claims and may also lead to change in the law restricting the free movement of ships. As ITO's Judge Kolodkin called attention in his 2004 declaration in the Juno Trader case, the United Nations General Assembly, in its annual resolutions on the oceans and the law of the sea, appeals to all states to harmonize their legislation to bring it in compliance with the UNCLOS since 1994. India and Japan can support these resolutions and call for all the relevant states in the Indo-Pacific region to harmonize legislation, including their own, in strict compliance with UNCLOS. In the interview of the Japanese Foreign Minister Taro Kono by Nihon Keizai newspaper on 26 October this year, Mr. Kono pointed out that the freedom of navigation is crucial not only for avoiding the militarization of the South China Sea by China, but also for being the precondition of China's One Road, One Belt initiative, and he intends to attach great importance on the coexistence of China and other countries. Therefore, to keep a patient dialogue on the strict compliance of UNCLOS with those states hindering the free movement of ships is what India and Japan can do together as important strategic partners. And thank you very much for your attention.